41, the people of the state of New York versus Jonathan Batticks.
May it please the...
Why don't you wait a moment and we'll have this first group clear out. Thank you.
Thank you, Your Honor.
You're welcome. Counsel?
May it please the court, may I also remain seated for this argument?
You may, sir.
Jonathan R. McCoy with the Legal Aid Society of New York, here today on behalf of the appellant, Mr. Jonathan Batticks. May I reserve 2 minutes for rebuttal?
You may.
Thank you, Your Honor.
You're welcome.
At the heart of this case, of this appeal, the issue at the heart of this appeal is what conduct on behalf of a juror, on a juror's part, requires a trial court to undertake a Buford inquiry. I submit that in this case, the facts that are presented to this court are far afield from those contemplated by Note 4 of Buford. This is not an unusual case involving an obviously trivial matter where all parties agreed that the jury's impartiality could not be affected. Instead, we're confronted with a case where a juror interrupted the proceedings to announce that she was very offended by co-counsel's cross-examination of the complainant in which he used and or repeated the phrase "old N-word."
Counsel, can I just clarify one thing? You seem to perhaps conflate a little bit the two tests, one of grossly unqualified and the other of misconduct of a substantial nature. Did you raise the misconduct issue in the trial court?
I don't believe any of the counsels below explicitly stated that they believed that she had committed substantial misconduct.
So do you agree that we should be focusing on the grossly unqualified standard here?
I think that the two standards in this case kind of bleed into one another, insofar as counsel's arguments as to why she was grossly unqualified all relied upon what constituted substantial misconduct. She committed misconduct by speaking out from the jury box, violating the court's admonitions, and that conduct became substantial misconduct when she threatened to act unlawfully by striking herself as a juror.
In other words, you're saying that the misconduct made her grossly unqualified?
Her misconduct evinced an ability to remain fair and impartial to the defendants in the case.
Grossly unqualified.
Yes, Your Honor.
So, when you say that she is no longer able to be fair and impartial, that's based on what exactly?
The fact that she was taking the line of questioning personally, and in fact stated that she found it very offensive, which implicated her ability to remain fair.
You know, lawyers say all sorts of offensive things in the course of trial, and jurors are offended. It doesn't mean that they have necessarily departed. And here the court actually observed everything. Right? It's not like something that happened. When you do a hearing, for example, into substantial misconduct, it's typically when that misconduct has occurred outside of the presence of the court, and you need to sort of get what the facts are. What is it that you think the court was going to learn by conducting a hearing?
By conducting a Buford inquiry, the court could have learned whether that juror could separate her emotional reaction from hearing the phrase "old N-word" used or repeated by co-counsel from her duty to be a fact finder in an impartial and fair manner. So the court could have interrogated what her emotional reaction consisted of, how strong that emotional reaction was to her or for her, and whether that would have impacted her ability to remain fair and impartial as a fact finder. And I should note that this court announced in Kudzal that all that's required to trigger a Buford inquiry is some indication that a juror may be grossly disqualified.
What about the fact that this whole discussion or line of questioning by counsel was not Mr. Batticks' counsel? It was counsel for a co-defendant who had raised a completely different defense than Mr. Batticks. Why, how does, even if everything that you say is true, how does that show any bias or impartiality toward this defendant, Mr. Batticks?
It shows a potential for bias or partiality against Mr. Batticks because they were all tried before a single jury under an acting in concert theory regarding the fight between the three defendants and the complainant. So the imputation of potential bias or partiality flows naturally.
Then isn't that always the case when there's a joint trial on those grounds? That anything that's said about one defendant is going to cause impartiality toward another defendant? Doesn't that sort of go against the whole policy there?
Well, I think that if the court had undergone a Buford inquiry in this case, this court could be assured, or Mr. Batticks could be assured that he received a fair trial, and the court could have gained knowledge as to whether she would actually be imputing any bias or partiality against Mr. Batticks himself.
Counsel, you'd agree that an inquiry of a sworn juror during the trial would be extraordinary by a judge. I assume you would agree about that. That's an extraordinary, it's not a usual step.
It's not a usual step.
So here's my question to you. So we review this issue under an abuse of discretion standard. Why wasn't the path chosen by this judge, the curative instruction, telling the jurors if they can't be fair and impartial, alert the court staff, and the judge will take whatever action was appropriate? Why wasn't that a more reasonable and measured approach than the judge actually inquiring of this sworn juror in the middle of the trial?
For several reasons. Mm-hmm. The first reason is that the court misinterpreted this court's precedent in Mejias and reaching its determination that a Buford inquiry was unnecessary. Secondly, this juror had already been admonished by the judge in open court, and to admonish her a second time through the use of the purported curative instruction may have only increased the amount of bias or partiality that she felt towards defense counsel for placing her in that position. So, getting back to...
I'm sorry, counsel, this, up here.
Sorry.
This trial court proceeding took place before our decision in Kuzdal, right? I think it was 2013, our decision is 2018. Would that have affected the trial court's ability to exercise its discretion here?
Well, the decision made by the trial court here certainly did not predate this court's decision in Mejias.
Right,
and
but Kuzdal
Mejias,
came after Mejias, so Kuzdal's now the law. Does that change your view of what the trial court was empowered to do here?
No, Your Honor, because in Mejias, this court stated that given some indication that a juror has engaged in some disqualifying conduct, then a Buford inquiry is mandated.
So your point is Kudzal didn't necessarily change that aspect of the law?
It did not.
That's not new law.
It was just a restatement of the law as it exists.
Thank you, counsel. Counsel?
If Your Honor will allow, I will also remain seated. May it please the court, Rebecca Hausner on behalf of the people. The juror in this case had an entirely understandable and foreseeable reaction to co-defendant's counsel's efforts to bait and goad the victim into having a reaction on the
Counsel,
stand.
that may be true, but that's not really the question, right? The question is whether or not the judge should have made an appropriate inquiry to determine what, if any, impact that questioning had on her, given her outburst and her threat that she would leave if counsel didn't change what counsel was doing during that cross.
First of all, Your Honor, I think that's exactly right, that it was within the court's discretion, and we defer to trial courts under these circumstances for precisely that reason, because they do have the ability to observe the juror.
No, I think we've said that if there's enough to trigger the inquiry, you've got to do the inquiry. You can't choose not to do the inquiry based on information you don't have because you didn't do the inquiry.
But in this situation, the trial court did have ample information before it. The trial court was able to observe the entire lead-up prior to the juror's reaction, and that context is important because the juror did not react the first time co-defendant's counsel uttered the epithet in this situation. She absorbed the evidence and no doubt saw that it was relevant to this co-defendant's justification defense at trial, and she didn't react the second time or the third time or the fourth time.
In the same way that the Chief Judge says, correctly so, it's unusual perhaps to make this inquiry. Isn't it unusual to have this kind of an outburst to threaten to walk out?
This was certainly a heightened expression of frustration in this sense,
why
but
would that not be even more cause for an inquiry?
It's all a matter of degree in this situation, and the juror did react with, as I said, a heightened degree of frustration, but this court has...
Excuse me, wasn't that exactly defense counsel's strategy? Didn't defense counsel here deliberately act in an obnoxious and aggravating manner to try and elicit a response? And he got the response, right?
Exactly.
That's what happened. So that being the case, it's clear to everybody who's ever sat in a courtroom that that's what happened. So if that's the case, doesn't a judge have an obligation to make sure that this juror is able to go forward and continue to be fair and impartial?
I think that it's correct, Your Honor, that the defense attorney was, to use your word, being obnoxious. And I think that's exactly why this court has created a carve-out for impatience and aggravation with attorneys, because jurors do react to the tactics and strategies of defense attorneys.
It's just a very unusual reaction. I mean, the reaction was so unusual that the DA at trial, I think, agreed that, said there was no reason for a mistrial, but would not object if the court chose to replace the juror.
Respectfully, Your Honor, the first thing that the prosecutor noted was that she agreed with the trial court's assessment that the reaction was tied to the frequency of the word of the offensive racial slur being uttered.
If he had just said it once, I agree with you. It wouldn't have created the situation. That's why I'm saying it seems obvious that he did it on purpose. But the DA did say that they would not object if the court decided to replace the juror.
Again, at first she agreed with the court's assessment, and I would just point out, Your Honor, that...
Well, do you agree with what I just said? The DA did say that. Didn't the DA then say that they would not object if the court chose to replace the juror?
Yes, Your Honor, but I do not think that that actually ties into the analysis for the reason I just described, but also it could be that this particular ADA was in fact advised that in these situations where there's the question of discharge of a juror comes up and you have your full staff of alternates ready to come in, that maybe her assessment was that it was better to sort of acknowledge the fact that she
seemed like a very practical response. Why have a case overturned because a juror made an inappropriate action in the midst of a trial? It seemed, given this case, I'm pretty familiar with it, it seemed like the DA made a very reasonable response.
Again, that may have been a reasonable stance to take, but she did align herself with the judge, and ultimately it was the judge's decision.
You know, for the DA to take that response, it doesn't necessarily mandate that the judge do that. That's the point.
Yes, Your Honor, and it was ultimately the judge's decision whether or not to conduct one of these very invasive inquiries, and the fact remains that this court has given discretion to trial courts in these situations.
Well, the discretion in our cases mostly shows up in the ordinary circumstance where, which is to Judge Feynman's earlier point, what the judge first has to evaluate is information from a spectator, from somebody in the hallway, from another juror saying, essentially repeating hearsay to the judge, and the first thing the judge has to do is figure out, what is this information? Is this person who is, as in Kudsdahl, providing the information credible? None of that has to happen here, right? The judge has actually perceived that there's not a factual issue that we normally have in these Buford cases, right?
Correct.
And my concern here is, which shouldn't surprise you, is the following: that the juror has demonstrated herself grossly unqualified because she has taken over the cross-examination. Put the shoe on the other foot, which is sort of what Judge Fahey was asking in a way. Suppose this had happened to you while you were trying a case, and you started asking some questions, designed perhaps to get some kind of reaction out of a defendant who was testifying on his own behalf, and a juror got up and said, if you ask that one more time, I'm walking out. You don't want an inquiry?
Respectfully, Your Honor, the issue that the defense attorneys were concerned with below was the potential that this juror was harboring some animus against one defense attorney, co-defendant's counsel. None of the defense attorneys below, not the court and not the prosecutor, were concerned with the misconduct aspect that appellant presses on appeal. No one was concerned with her ability to abide by the court's instructions, and in fact, her conduct for the remainder of trial proved that she was able to abide by the court's instructions. So the whole issue of steering the cross-examination away from what the defense attorney initially intended was not even raised as a complaint by the defense attorneys below. And I think that's exactly because he could get out the evidence that he wanted. He already had gotten a concession out of the victim that he may have been called a racial slur that preceded the violence in this case. And all the parties in the courtroom clearly knew that he had already gotten what he wanted. And this fifth and final use of the racial slur was entirely gratuitous for that reason.
Well, we don't really know that because we don't know what the next question would have been.
We know from his summation, we know from co-defendant counsel's summation that he was concerned with demonstrating
in any event, your answer to my question seems to imply that you would have wanted an inquiry of the juror. It's just that here they didn't ask for that and it's not preserved.
I can't say whether or not this defendant's attorney wanted an inquiry. In fact, he was the one who had requested a mistrial, so I can't speak for what his trial strategy was. But the record does show that he was trying to get a rise out of the victim. That strategy didn't pan out. He got a rise out of the juror instead. But again, that expression of frustration demonstrated her irritation with the tactic that co-defendant's attorney had chosen at trial. It was not an indication of bias, and it certainly was not an indication that she couldn't remain fair and impartial. And I think that's exactly why the trial court in this situation fashioned the remedy that it did. It gave leeway, it left open an avenue for this juror to come forward and express any concerns that she may have had.
But in part, you seem to be equating what she is saying is difficult for her to continue to like any other irritant. And it's not. As you said, it's a racial slur. It has a particular history. We don't even use all of the letters in this particular slur as a consequence of that history. So how is it that a judge, having observed this, having heard this, does not have an inquiry to see whether or not, given what is the cause of her anger and frustration and her outburst, may have some lingering effects beyond, okay, now you're not going to do it anymore, I can move on?
I think, again, that's exactly why the judge created this avenue for her to come forward. I think based on his own observations, it was entirely tied to the repetition and her frustration with the repetition, because if it wasn't, she would have reacted the first time. But he left open this avenue, and I think this court has said in Mejias, and it said in Kuzdal, that trial courts do have the discretion to form these preliminary steps instead of launching directly into a potentially unwarranted and uncalled for invasive inquiry.
Well, what's the downside in this case, given that this is so unusual and so outrageous to say to a lawyer, if you don't stop, if you just don't I don't want you to do that anymore, otherwise I am getting up and going. I'm gonna stop my service on this jury. Why is it so unreasonable to say that requires the judge to make an inquiry of her, of that juror, excuse me?
Initially, Your Honor, I would disagree with the characterization that she was...
I mean, the judge might come out after that inquiry and decide that she should stay seated, right?
Initially, the characterization of the record that she was attempting to strike herself from the jury or no longer wanted to deliberate...
I don't know, it says, or I am leaving.
And that was a reflection of the fact that she did not want to hear the word again. She had grown tired of hearing the word because it was uttered so gratuitously, because it was so unnecessary. And is it possible that the judge could have done an inquiry in this case? It's possible that a judge could have done the inquiry, but the point is that the law doesn't require him to do an inquiry in this case. An inquiry was not required. He instead elected to pursue a completely reasonable and effective strategy of admonishing the juror, removing the jurors from the courtroom, soliciting input from the defense attorneys, and then instructing the jurors that they couldn't hold questions asked against the parties, they should not prematurely form opinions, and that they should come forward if they had any concerns. And of course, the record is perfectly clear that she did not come forward with any concerns, and nothing about her demeanor during the duration of the trial
Of course,
raised
now
any...
if she harbors particular hostilities, she may not wish to do so, and it may very well be that she would react differently if inquired by the judge face to face.
Again, Your Honor, I think that is why we leave these issues to the trial court, who had the benefit of observing her demeanor in court.
Thank you, counsel.
Thank
Mr.
you.
McCoy?
Thank you, Your Honor. Respondent argues that the curative instruction that the court formulated for the jury was the same kind of preliminary curative instruction that this court found to be acceptable in both Mejias and Kudzil. However, that misstates the facts of the record. The judge in this case stated after the request was made for the inquiry that he would not be giving an inquiry because of his misinterpretation of the holdings of Mejias. And then and only then did he give the jury the option to volunteer themselves as possibly to make that legal determination, if you will, of whether they were fair and impartial or could not remain fair and impartial. And then sidestepping the procedure prescribed by this court in Buford as the means for determining whether a juror could remain fair and impartial, that juror was to report to a court officer, and in that judge's words, there would be no question after such a report that he would then discharge her. That is anathema to what Buford and its progeny represents. And speaking to the point of speculation, when the court and when the lower court stated that without hearing anything else from a juror, that it would assume that all the jurors could remain fair and impartial, it was basing its assessment of Juror 6's partiality or impartiality necessarily on impermissible speculation, which again is anathema to the Buford and its progeny. And just one last note. The Buford inquiry is supposed to be tactful and probing of the potentially unqualified juror. So while it may be unusual to engage in the inquiry and with regard to the full span of cases a judge might have on their docket, the tactful and probing requirement ensures that the inquiry gets to the issue of their fairness, impartiality, their qualifications as a juror, and as was noted, can in fact rehabilitate that juror.
Thank you, counsel.
Thank you, Your Honor.